A last will and testament is the most well-known estate planning document in America. But in Florida, it has very specific rules. Get one of them wrong, and the entire document can be thrown out. A last will and testament, often just called a will, is a written legal document that tells the probate court how a person wants their assets distributed after they die. In Florida, wills are governed primarily by Chapter 732 of the Florida Statutes. A will does four main things. It names the personal representative, which is the person responsible for administering the estate. It names the beneficiaries, the people or organizations who inherit the assets. It can nominate a guardian for any minor children. And it directs how specific assets should be distributed. One important point. A will does not avoid probate. A will is a set of instructions for the probate court. The court reads the will and follows it. Assets that pass under a will still go through the probate process in Florida. Florida law sets strict requirements for a valid will. Under Florida Statute 732.502, the will must be in writing. The person making the will, called the testator, must sign it at the end. And two competent witnesses must sign the will in the presence of the testator and in the presence of each other. All three signatures must happen in the same session. Florida courts apply this rule strictly. A will signed without two witnesses present together is not a valid will, no matter how clearly it expresses the person's wishes. Florida does not recognize handwritten, unwitnessed wills, known as holographic wills, even if they are valid in other states. To make probate faster, most Florida wills are made self-proved. Under Florida Statute 732.503, the testator and the two witnesses sign a notarized affidavit, usually at the same time as the will. A self-proved will can be admitted to probate without the witnesses having to appear in court years later. Florida also allows electronic wills under Florida Statutes 732.521 through 732.525. An electronic will is signed electronically during a live online notarization session with a Florida notary and two witnesses connected by audio-video technology. It is not the same as signing a PDF. Strict statutory procedures apply, and an electronic will cannot be used if the testator is a vulnerable adult. Florida does not recognize holographic wills, even ones that are handwritten, signed, and dated by the testator. If a Florida resident dies with only a handwritten will, the court will treat it as if no will exists and will distribute the estate under Florida's intestate succession rules in Florida Statute 732.101. This is one of the most common ways a Florida will fails. A will is the foundation of most Florida estate plans. But it only works if it is executed exactly the way Florida law requires.